So is there a statute of limitations? What if you don't work for a company, it's been, 2 years, 3 years, 5 years, but the fraud occurred back in the day, or you still work for a company and the fraud happened a while ago? Is there a limit by which you can't bring a Qui Tam case?
There are statutory limitations, all right, at the federal level, and also various states have their own Qui Tam legislation as well, whistleblower statutes, and they vary by state and varies by incident. But by and large, the emphasis really should be that it should be as close as is possible to the actual ongoing fraud or fraudulent activity to make it timely. What the government looks for, and I should have said this earlier, it's wonderful to bring to the government's attention the fact that fraud has been committed and we can prove the fraud. But the problem that may come down to the government will have these elaborate algorithms, right, that they basically try and quantify the extent of the fraud. What do I mean by that? Let's say in New York, for example, your typical radiologist does 1.9 MRIs per patient every 4 years under his care. That may be the norm. Everything is so computerized right now that the government can look at a particularly, let's say a radiology group, and say, my God, okay, they're averaging 7 MRIs, not 1.9. Either they're seeing some really bad spinal cases on a consistent basis, or they're doing procedures that shouldn't be done. And the second element of all this is, even if you have a great case, the government's concern is, can we recover? So if you have a great case against a hospital that's filed bankruptcy, the government may be less inclined to take it. If you have a strong case against an ongoing medical enterprise with ongoing revenues, the government may be more inclined to prosecute those kind of cases.